Our first speaker today, who we've allotted a grand total of 20 minutes to give a full update on just cause for discharge, so please make allowances for that, is David Cote. David is a very effective advocate, speaker, lecturer, instructor, and in fact, I've had a number of cases with him. Some have been knockout or drag-outs, but pursuant to Justice Gans' suggestion, we've always settled our cases in the end. David is also a scintillating speaker, as you're about to find out.
Well, I'm really interested to find out if I'm a scintillating speaker. I was told once that when you have the opening slot on a conference day, particularly a day that's cold like this, you want to take a crack at trying to tell some sort of a humorous anecdote. Of course, the risk is that the humorous anecdote will fall flat on its face. I suppose that risk is a little bit worse when the audience is a group of lawyers. But having said that, let me try the humorous anecdote. And the anecdote I want to share with you is from a book written by a guy called Mark Stevens in the 80s. And it was called The Power of Attorney, and it was all about what big law firms were doing in the 1980s. I don't know if the book's relevant or not in the 21st century, but the humorous anecdote goes like this, and he's talking about challenges managing partners will face as they moved into the 1990s. So obviously this is just useful for humor value, we hope. Managing partners will likely face the same predicament as the senior partner in a major New York law firm who was asked by the Manhattan Chamber of Commerce to address its membership. Accepting months in advance, she forgets about the engagement until cleaning off her desk late one Friday evening, she notices the date scheduled in her calendar for the following Monday. With a big weekend at the beach house on tap, there's no time to write a speech. Instead, she calls in a bright young associate. Scoggins, I have to address the chamber on Monday night, and because of a client commitment all weekend, I can't do it myself. You'll have to write it for me. Have it on my desk by noon. Scoggins tries to tell the senior partner that he hasn't seen his spouse in 7 weeks and they've got reservations to go away, and the partner rudely interrupts. No ifs, ands, or buts, Scoggins, on my desk at noon. Come Monday at 12, the speech is prepared, freshly typed and bound in a neat plastic folder. The partner, on her way to a client meeting that will last until the evening, stuffs the speech in her briefcase without reading it. Later that night, standing before the audience of 500 business executives, many clients and potential clients, she delivers the speech, which turns out to be a literary pearl filled with humorous anecdotes, wonderful insights, and bright observations on the law, business, and modern society. Near the end, it reaches a crescendo that has the audience literally on the edge of its seats. Before I leave you tonight, the partner intones, I want to share with you my ultimate vision for using the law not only to resolve disputes, but to create a new chapter in the history of mankind, a chapter of unparalleled peace and prosperity worldwide. To accomplish this, I suggest that she turns the page, curious herself to read this remarkable plan, only to find in capital letters, "Fake it, you son of a bitch." So, there's the attempt at a humorous anecdote. Now on to the update for cause. I think I've used already 5 minutes of my time. And it seems to me that before we get into a discussion on what cause is, some basic concepts are helpful. We all know that employment relationships are nothing more than contracts between two parties. The parties are the employer and the employee. The employer agrees to employ the employee. In return, the employee agrees to work for the employer. The employer pays the employee money and benefits and perks, and the employee agrees to do a good job. And so that's all pretty basic. Now, we also know that employment law permits employment relationships to be terminated. And they can be terminated generally either on reasonable notice or compensation in lieu of notice, or they can be terminated for cause. And so then the question becomes, what is cause? And an illustration of what cause is that Howard refers to in his book, I think David Harris has referred to in his book, is the off-cited decision of Port Arthur Shipbuilding. And we can see the quote. It's out of the mid-'70s by the Ontario Court of Appeal. If you've got an employee who's been guilty of serious misconduct, if she's habitually late, if she habitually neglects her duty, if she's incompetent, or if she engages in conduct that's incompatible with her duties or prejudicial to the employer's business, I was told by the Law Society to try to gender neutral the language. And I didn't want to take the his's out of the quote because I'd be unfaithful to the quote, so I'll substitute his's for hers. Then you've got cause. You've got cause to terminate the employee's employment. Now, the paper that's been handed out will deal with a number of types of conduct that the Port Arthur shipbuilding decision anticipates. And we clearly don't have time to do that. Instead, what I want to do is talk about a few cases. And we'll see the first case on the list is Felker. I understand my former good friend Mark Ellis spent essentially his entire presentation yesterday on Felker. And so rather than me taking you through material that you've already heard, I'm gonna skip ahead on my PowerPoint presentation and get down to some of the other cases. So let me just take it off the screen for a sec while I do that. And I want to go to a case called Gaudio. Let me see if I can get this back on the screen and on my computer. Yes, I can. Let me go to where I need to go in my hard copy, and we'll talk about Gaudio and Banca Commerciale Italiano of Canada, and I bastardized the title, for which I apologize. Now, it's a recent case, a 99 decision, and one of the reasons I put the case in is because it demonstrates how hard it can be to establish cause, particularly where the alleged cause is just one instance rather than a pattern of instances over time. And so let's put the facts up and have a quickie look. We've got a plaintiff who was a bank manager. I recall him being about 37, 38 years old, about 3 years service with the company, and he's earning about $60,000. And one of his job responsibilities as the branch manager was to make sure that loans with the bank were properly serviced and didn't go into overdraft. And there's where the problem arose. The loan went into overdraft. And if I can just grab my copy of the Gaudio case, we'll see that in the decision, extensive reference was made to some policies that the bank had. And let me just see if we can find those. Well, we're not going to find them quickly, but in summary, there were written policies in capital letters underlined. And Mr. Gaudio, like all employees, signed off on those. And there was no question in the mind of the court that the written policies made it crystal abundantly, couldn't be clear that if a loan went into overdraft, Mr. Gaudio, like any other senior manager, because he was the branch manager, would need to fill out one of these overdraft reports and send it off to 15 different departments within the bank, so that head office of the bank, in addition to local management, would be up to speed in terms of what was going on. And the court found that Gaudio ought to have reported the overdraft, but hadn't. Now let's going the wrong way. Sorry about that. Now, despite this, the court concluded that the plaintiff had been wrongfully dismissed, and the court concluded that he'd been wrongfully dismissed, despite the fact that these policies weren't properly complied with, but ended up saying that it was only one instance. The employee did have 3 years of service, which from a management lawyer's perspective isn't all that long, but in the court's eyes it was, and that generally his performance appraisal reviews were reasonably decent. The other thing that the court noted was that Mr. Gaudio did tell his immediate superior about the overdraft problem, and Gaudio and the superior were trying to work together to get the problem resolved. Now, I mean, again, speaking from an employer's lawyer's perspective, the problem with relying too much on that, of course, is that one of the reasons these policies are put in place in the first place is to make sure that head office of an organization, whether it's a bank, a widget company, a high-tech company, or whatever, has some reasonable comfort that folks on the floor aren't either acting incompetently or aren't acting in concert with each other. And one of the things that I found interesting in the case is that while the court did give credence to that purpose as being an acceptable and useful purpose. Seems to me it then sort of went on and somewhat ignored that purpose by concluding that Mr. Gaudio hadn't engaged in cause again. Why? Because in part, he had told his manager about the problem and they were attempting to work it out. So there we go. That's Gaudio and an example of how difficult it can be to establish cause successfully when you've got a single case of misconduct. The next case I want to quickly move on to, it's a fun case, and it's called Thompson and Lex Tech, Inc. And again, it's a 99 decision out of the Ontario Superior Court of Justice. Once again, this case can be seen as how difficult it can be for an employer to successfully dismiss someone for cause when you've only got one instance of misconduct. It's also a very good example of how you've got to be really careful if you're representing an employer or if you're representing an employee, how it can be useful to try to rely successfully on things like provocation by an employer or a personality conflict with a supervisor. And one of the reasons this case is fun is because it's just very clear that poor old Mr. Thompson had a real bad day. He got up for work in the morning, his kids had left the garage door open, and a skunk had decided to inhabit the garage. So he called the company and said, look, I'm going to be a little bit late, I've got some stupid skunk in my garage and I'm trying to get it out, but I think I should be there on time. What he didn't tell the employer was he'd also recently had a vasectomy. Now, he didn't tell the employer he had a vasectomy because he didn't think it was any of the employer's business. And he had to stop into a lab on the way to work to drop off a sample. So he didn't tell the employer that. He gets the skunk out, he gets in the car, he's rushing off to the lab to drop off the specimen, gets horribly stuck in traffic. Okay, so he's an hour late. And he didn't have a cell phone, so he didn't call in, nor did he pull off the road to look for a payphone. This was something the employer was quite upset about. So he gets to work, he's in a bad mood, and the supervisor just starts riding him. Because by then the skunk story had gotten around the plant. So the supervisor made some sort of crack like, oh, more skunk troubles, Gary? And Gary wasn't terribly pleased with that, and he said something like, no, I was having bacon and eggs with my wife. Well, the supervisor didn't take too kindly to that. I think I have to get back up on the stage.
They're filming.
They're filming or taping or something. And so the supervisor got a little exercised with poor old Mr. Thompson and insisted on following him around the plant, demanding an official explanation for A, why he was late, and B, why he hadn't called in. Well, suffice it to say that things escalated quickly. There was a lot of profanity, including some by Mr. Thompson, and Mr. Thompson pushed the supervisor twice. So he engaged in an assault. And all of this fracas, it went on for a good 10 or 15 minutes. I mean, they were chasing each other through the plant. At that point in time, Mr. Thompson says, you know what I'm doing? I'm getting the hell out of here to go think about what I've done, which is an interesting thing for Mr. Thompson to say. It was a Friday. He took off, comes in Monday morning, and has waiting for him by the supervisor a letter saying that he's been dismissed for cause. He sues for wrongful dismissal, goes to court, and the court concluded that there wasn't just cause to dismiss him. Why? Because the reasons for Mr. Thompson being late were legitimate reasons. The court didn't really think that it was up to Mr. Thompson to pull off the highway to try to find a payphone. The court didn't think it was particularly necessary for all employees to have cell phones. And the court, I'm just being told I've got 3 minutes, and the court was also impressed by the fact that the supervisor was being a bit of a wiener in kind of setting this thing up, and the court also concluded that there'd been a bit of a personality clash. So in sum, the court says you've got a decent employee who's trying to do his job, he's got decent performance appraisal reviews, and you had a bit of a personality clash and a bit of provocation by the court or by the employer, and therefore cause was not upheld. Now, I've got about 2 minutes left, so let me just talk very quickly about a poor performance case. We all know it's difficult to prove poor performance. There's a case, there should be a handout, it's called Heisel and the Salvation Army. It's a 98 decision, Superior Court of Justice. Very, very quickly, Mr. Heisel was in his 60s, he was a social worker, and he worked for an agency that helped inmates in prisons get back to work. He consistently had poor performance appraisal reviews. He was consistently told by his employer that he's got to follow written policies, he's got to get his timesheets in, he's got to get his sociology reports done, he's got to make sure the inmates get their medication. Heisel's defense at trial was that, you know what, I'm an experienced social worker, I've been in the business for 30 or 40 years, don't bug me with these silly written policies. I know what I'm doing. And so, the trial court concluded, look, you may well know what you're doing, on the other hand, you may well not. Part of the problem is the employer can't tell when you don't follow written performance appraisal requests and written policies. And so based on the facts that A, the employer did have written policies, B, the employer did have well-documented performance appraisal reviews, which told Mr. Heisel what was wrong, which told him what was required, and which gave him a reasonable period of time within which to do it, and the fact that Mr. Heisel did a little bit of this for the camera, sort of in your face, I'm not doing it, the court concluded that there was cause. And so it's an example of a case where an employer did successfully rely on poor performance to establish cause for dismissal. Come at it another way. The reason that's often difficult for an employer to do is because poor performance is such a soft issue. And so if we all imagine ourselves judges sitting up on a bench, what we're looking for is objective evidence to grasp onto so that we are comfortable that the employee really did know what was required of him and just failed or was unwilling to do it over a particular inconsistent period of time. So I bet you I've gone from 3 minutes to 0 minutes. I understand people were a little ticked yesterday at speakers going over time. I'm not going to go over time. So I'm going to stop, just remind you that the paper is a lot more extensive than the PowerPoint presentation, and copies of the cases I believe should be enclosed. Thank you.
Just 20 seconds on Manny Heisel. I acted for him about 15 years ago, and he was also fired for cause, so this wasn't anything unusual for him.
Let me just get out of this, and I'll get my computer out of your way.
David is right that it's always best to start a cold morning with good humor. And the best humorist in the bar is Barry Fisher, who is our next speaker. Barry has gone from being a very successful employment lawyer, acting primarily for plaintiffs, but for both sides, to a very successful mediator who has resolved, virtually every case that goes before him. He's got a very good success rate.
I've never had a case in front of Barry that I wasn't able to resolve, even with Howard on the other side. Oh, sorry. Was the mic still on?
Sometimes.
This is going to soon become the Mr. Justice Gans fan club.
It'll be his first.
Cote gets out of here.
I'm getting out of here.
Are you going to have a PowerPoint too?
No.
He's technologically challenged. Oh.
Good morning.
You're already going to give you the 3-minute...
A 3-minute warning already. Well, actually, the only problem with my speech is probably going to be to occupy the 20 minutes, so you may appreciate its brevity. I'm talking about reasonable notice. I didn't choose it. They stuck it with me. I would have rather talked about mediation, and if I have time, I'm going to stick in comments on it anyways. This is about the 14,000th paper I've written on reasonable notice. So I was training to try to find something new on it. Let me start off by saying there ain't really a whole lot new about it. You're not going to learn a whole lot. Not much has changed since the last time I looked at these sort of things. I used to study things like, have notice periods gone up, have they gone down? I usually concluded they went sideways. Most of you probably know, and if not, I'll give the sales pitch, that I'm the author of this thing called the Wrongful Dismissal Database, where I basically read every wrongful dismissal case across Canada, and I correlate into the database any case that comments on reasonable notice. The database breaks down what I call primary reasonable notice, which is reasonable notice as assessed by the typical Bardolph factors. And if the case adds notice by way of a Wallace factor, the database tracks that, but we track it separately. So in other words, the database maintains the integrity of determining what reasonable notice is, and then has a note to show that there's an add-on if there's a Wallace factor. That's something that you should be careful of when you're reviewing other materials where they state what reasonable notice is, because obviously a Wallace factor add-on can greatly distort the reasonable notice. You have that idiotic case in BC, Glendenning or something, where some judge awarded 42 months as a 6 months reasonable notice with a 36-month extension because he didn't like the way this certain person was treated. If you, for plaintiffs, you put that on your chart, you're going to lose a little bit of credibility with the judge, saying that this is proof that all 5-year clerks are worth 42 months.
Barry, just for a second, that was appealed? Do you know what happened on the appeal?
No, I don't. I never followed up on it. Maybe they went to mediation and they sawed it off and settled for 26.
That's your pitch.
God, what a terrible deal that would have been. So the first thing is not a lot has changed. So since not a lot has changed, what I did was I sort of went back and sort of asked myself other questions that I hope will be of some utility. In the past, I've examined things like, I used this database to try to determine whether the popular myths, as I called them, of reasonable notice actually pan out statistically. It was part of the reason I started the database, because when I was young and starting out in this area, people used to just throw around notice periods, and I was duly impressed and had no idea where it came from. And then I realized that most lawyers' experience was based on the last 3 cases that they personally remembered. So I've been using the database over the years to try to determine whether these urban myths are true. So I've examined things like whether, at one point we all thought BC was a whole lot more generous than Ontario. I looked at that. I looked at whether there was really how important was age as a factor vis-a-vis service, how important was occupation vis-a-vis service. And then the last major study I did was, I was very worried when a case, I think, what was it, Marcotte, came out, and it looked like there was going to be this rule of thumb, which would have completely wiped out the economic base of my database, and to say nothing, in fact, of taking away 90% of what we all do. So I studied that carefully and determined, thank God, there wasn't such a thing as a month a year per rule of thumb and that. So on this one, I've done a little bit a different analysis. And these things are just to sort of help you in eyeballing and assessing reasonable notice, either whether it's on the phone for that 5-minute quickie that the employer calls you, or going into a pretrial and arguing that the offer is reasonable or not reasonable. Let me just say, having been studying this area now for 20 years and written and everything on it, the level of unpredictability in any given fact situation still continues to be utterly and ridiculously shocking. Right, and this comes right, the only nice thing about the rule of thumb was I thought, okay, at least it's going to be predictable. And the court again said, no, every case is individual. I still do not understand why judges think that every case is individual. An event that occurs thousands of times across Canada every single day that affects common men and women, I have no idea why the courts continue to think everyone has to be individually analyzed. I would have thought that, having represented numerous plaintiffs and employers, certainty is probably the highest factor that they want. They would like to know. If they walked into your office and you could say with certainty that your case is worth 8 months or 9 months, they'd probably like that answer better than it's worth 6 to 12. The analogy is always given is, would you ever hire a plumber who came to your house, looked at what it would cost to fix your sink and said, it could be $300, could be $3,000, I'll tell you when it's over. Who would ever hire somebody? So part of my sort of legal and moral reason for studying this is to think that maybe judges will read them and then be more consistent, but I'm pained to say that I haven't seen that. Okay, the first thing I did, if you turn to tab, I think I'm at 16. Unlike Mr. Cote, I don't have the vast IT department of Baker McKenzie, so, and I also always hate looking at those things because if you're at the back and you got eyes like mine, you can't see them anyways. So I've just put it in good old-fashioned paper. And the first thing I did was a typical profile. What I did was I asked the database to spit out for me all the cases, for instance, where someone got 24 months. So if you look at page 16-3, you'll see at the top, notice period 24 months. Size of sample simply means out of about 2,200 cases in my database, 32 of them had notice periods of 24. It's still a relatively, rare notice period. The medium service, and remember back from grade 11 math, there's the average and there's the medium. The medium is the midpoint. So if you have, whatever, I'll make an easy number here, if you have 32 samples in the database and you rank them, in this case I would have ranked them from lowest service to highest service, the midpoint, like the number 16 I guess I used, was 27.6. So that's actually, and you'll see later on I study that, that's actually a better way to look at these things sometimes than the average. Remember, the average Canadian has 2.3 children, but no single Canadian has 2.3 children. That's the classic difference between an average and a medium. Some of us even have 4. It's all right, recently.
Barry refers to the fact that he recently had a new baby.
A new baby girl, yes, thank you. Which I'm much more proud of than another paper on reasonable notice. That was from my wife, if she ever sees this tape. So the typical person who gets 24 months has 27.6 years of service and is 55 years of age. So, and you'll see I've done it, I basically did it for all notice periods going up in 3s. I just thought this would be a useful, again, most of us are asked to give off-the-cuff, poorly thought out responses to what's reasonable notice, be it at a cocktail party or in a mediation. And this is I thought this would be a useful guide to say, well, you know, yes, you are a hardworking clerical employee who's been there well over 2 years, coming up on your 3rd year, and you're in your 30s, but the odds of getting 24 months might be a touch slim. Wait another 25.6 years and get some gray hair, and then maybe you'll be in the category of the 24-monther. So I did this, and you can see there's no real great surprises here. As notice period goes down, medium service goes down, and age goes down. Surprise, surprise. But if you want the big monies, you better be in your over 45, because those are the people that get the big money according to the chart. Also, the medium age is interesting, which is not surprising. Most lawsuits are people who've been working for some period of time. That doesn't mean if you're 38, you're not going to win a wrongful dismissal lawsuit. Remember how to read this. This chart does not take into account occupational differences for a number of reasons. First of all, statistically, it's impossible to do so. Secondly, and more importantly, occupational category always has struck me as the least relevant or least intelligent criteria. I have never, the theory has always been, I used to explain to plaintiffs, the older you are, the more you get. The longer you've been in one place, the more you get. And as I used to so eloquently do it, the higher you are up the corporate dung heap, the more you get. None of these things probably have any direct relationship to how long people are actually unemployed. Funny enough, this area of law has been around for a long time. I've never seen anyone actually present a study which would say that someone who's 35 years of age being employed with the company for 2 years, as opposed to someone who's 35 years of age and being employed with the company for 10 years, would have an easier or harder time to get a job. So we just accept these things as sort of social goods, that we sort of accept the premise that the longer you've been with a company, the more you should get. It's sort of a doctrine of severance, really not related to unemployment. And there's this theory that older people have a harder time getting a job, which is applicable to certain age groups. I don't believe a 35-year-old has a tougher time getting a job than a 22-year-old. I think it's probably the reverse, frankly. But the one that's always bothered me is the occupational category, this theory that a secretary will have a tougher time getting a job than a senior executive. And in one of my papers, I commented on that in the sense that, well, people say, well, there's less senior executive positions available. Yeah, but there's less people competing for that same position. A real study that I've never seen anyone do would be to compare the number of unemployed secretaries compared to the number of secretarial positions available and look at the ratio. If there's 10 unemployed secretaries in a city, and there's if there's 100 unemployed clerks in a city and 10 positions, then that person has a 1 in 10 chance of getting the job. There may only be 4 senior executive positions available in any day in a city, but there may only be 5 people competing for it. So statistically, that the executive has a much better chance of getting a job. So the only case that has actually recognized this, and it hasn't had any effect from what I can tell in Ontario, is a case called Bramble versus Metis Health out of the New Brunswick Court of Appeal, which basically said, it read the occupational category in Bardol out of existence in an extremely intelligent way. I love how lawyers can think. Well, we can't upset Bardol, they said, because it's been confirmed by the Supreme Court of Canada. So character of employment is definitely a valid factor, but we're not going to take judicial notice of character of employment. You have to present evidence. The employer didn't present any evidence. We're going to ignore it as a factor. Very clever way to do it. Now, just New Brunswick, who cares? You know, they're off there, whatever, getting lobster. It's not going to affect the real law. New Brunswick is where Mr. Justice Bastrash, Ben, I better get it right. Bastrash, is that how you pronounce his name? The Supreme Court of Canada comes from, okay? And when he was interviewed prior to getting on the Supreme Court of Canada by a Canadian lawyer or something like that, he was asked, what are you going to do about criminal law and all that sort of stuff? And he was asked, what about employment law? And he sort of mused. I've always wondered why occupation is a relevant factor in wrongful dismissal cases. So I think one of these days, maybe when Howard brings his next case to the Supreme Court of Canada, or some group out there actually will take a clerk's case all the way, I think you're going to see the Supreme Court of Canada once and for all demolish occupation as a relevant category. It's certainly diminished. In my studies, I looked at the relative weight of the 3 factors, and again, seniority, the years of service, is the dominant factor. It's also the only factor used in statutory determinations of severance, interestingly enough. The Employment Standards Act doesn't say you get more money if you're a clerk or anything. Okay, how much time do I have?
You're okay.
Okay, what does that mean? 10 minutes? 5 minutes?
Give you 6.5 minutes.
Oh, 6.5
If you're really
minutes.
good, you can have 8.
I could have 8. Okay. The next thing I looked at was, and I touched on this a little bit, on page 16.5, or 16-5, is looking at the medium versus the average. For those of you who may have used the database, you'll notice that it prints at the end the average notice period. And there's a warning at the front that says this is the statistical average only, should not be relied upon. But I've noticed that a lot of people, you know, like everything else, you pick up a cheap novel, you look at the last page, you pick up, if you pick up the database, you look at the average, and everybody goes with the average. So I did a study of the average versus the medium, because when I look at the results of the database, I don't actually look at the average. I look at the group of notice periods that is most dominant. So that if there's, say, 20 cases in the sample, and 8 of them are 12 months, and then there's some weirdos at the low end and weirdos at the high end, and the average is 10, then the better predictor of what a single judge will do is the largest grouping. What notice period the judges choose the most often, which is roughly the medium. So I did a study then I took years of service from 1 to, or from 0. There actually are cases where 0 covers anything from never started work to less than 1 year of service. And you'll see there's 223 cases in that. It's a huge area of litigation, the short service cases, and also the most unpredictable. They're all over the map. I have no idea. What some people get for not working at all is unbelievable.
It's the inducement issue probably, right, Barry?
No, actually, these tend to be factored out inducement cases, because I treat those as Wallace factors, so they shouldn't show up too many of those in the database. It's just all over the map. Sometimes you're better off not working at all. The judge finds you more sympathetic. I don't know. Anyways, so I looked at the average month's notice. So for instance here, if you take, say, the 8-year mark, people with between 8 and 9 years service, 69 in the sample, the average notice period is 9.04. The medium in that case was 9, so there's a correlation. The difference on the last category on the right shows where there's a variation. There's individual variations. A lot has to do with the sample size. When you get down to the larger notice periods and your sample size is lower, any single case will throw off the distortion too much. But what's interesting is the average difference between the medium and the average is only 4%. So I was actually quite pleased with that. So unbeknownst to me, the average is actually not that far off. So when you're looking at this data, you can look at the group that has the most single types of notice period. You can look at the average, and you can look at the medium. And I encourage you to sort of really study those, because it's, and the closer those three items correlate, the stronger your advice can be that, the way I always phrase it is, this data shows us that the highest likelihood that a judge will award a notice period for you is X. That's all you can say. Not guarantee or anything like that, just the highest likelihood that he has to choose some number. He's probably going to choose another number. Another study I did, which was fascinating, was the study of threes, which is judges choose notice periods in threes, 3, 6, 9, 12, 15. And it was fascinating. I studied the number of times that judges award 16 months compared to 15 months, or 17 compared to 18. And there was a clear correlation to multiples of 3. So again, in predicting what a judge will do, the odds that a judge will, in any given situation, will find 15 to be more reasonable than 16 is very high. So these are the sorts of things you can think of also in putting together offers to settle. In other words, putting together an offer to settle for 16 months is risky unless you're really going up against 18. If you think the case is worth 16, you're much better off saying 15 because you've got a higher correlation that the judge thinks in threes.
Barry, did you note that they often give 4 or 6, but never 5?
Yeah, and
How
16
many
is-
sevens?
Well, if you look back at my other paper, I can tell you how many sevens. No, it's bizarre. I don't know. Funny enough, Mr. Justice Finlayson, in a fascinating paper, and I rarely say that about him. Yes, I know. In a fascinating paper by Mr. Justice Finlayson, in the Court of Appeal, talked about the doctrine of threes also. Basically, nobody has more than 3 good arguments or 3 good points. Which told me that if you say you have 4 good points, the Court of Appeal sort of stops writing after your 3rd one. So there must be something about lawyers training in 3, I don't know. Okay, the last thing that I studied, or the second to last thing that on the next page, paragraph 16.7, just to show you my technical computer skills, I took all that raw data and I put it in a graph. Not sure why, but it had to fill up another page. This was actually to feed into the next category, which was the age-old study, the age-old question, sort of the rule of thumb revisited again. Is there a direct correlation, or is there some reasonable correlation between the single factor of service and notice? Yes. Okay, I'm being told to leave a couple minutes for questions. No problem. Let me just say then, looking at this chart. This is a direct correlation between, on the left, let me see, on the vertical axis is months of reasonable notice, and on the horizontal axis is length of service. So in other words, for people with, say, 3 years service, the average notice period is about 6. That's how you read that. What you can see here is it is not a linear straight line progression. Not surprising at all. There are 3 distinct groups of service in relation to notice. The short service, which is sort of under 10 years, the middle group of service, 10 to 15 years of service, and long service over 15. The most dramatic rate of increase in notice periods is in the short service period. That is over a period from 0 to 9, it is 171% average increase in the notice periods. In the middle group, that is the 10 to 15 years, it's virtually flat. In other words, the notice periods that you get for somebody with 10, 11, 12, 13, 14, 15 years of service doesn't change very much. And then after 15 years, it starts going up again, but a more moderate rate of climb. So again, another proof that they still need us, that it's not a simple correlation of per year of service, not even at the mid-range where it sort of flattens out. So you got a 12-year guy, he ain't going to get a whole lot more than a 14-year guy. Okay, so in conclusion, notice periods, as I say, continue to be a conundrum for practicing employment lawyers. Although there are definite statistical trends and predictors, some judges, as I say, will often cling to the belief that every case should be assessed on individual merits, and they frankly ignore or are not even conscious of, what I can tell, the precedents. The Wallace factor issue has thrown everything off the map. As a mediator, I have seen everything from horrible, severe treatment being called a Wallace factor to, I don't know, they didn't give me a bucket of roses and drive me home, and therefore I was really upset and I should get a Wallace factor. It's like the rule has become, if a plaintiff can't think up a Wallace factor, he shouldn't be filing a claim. But that's another thing. It's like in my day, everything was mental distress, so now everything's a Wallace factor. Again, all you can do with this is use this type of information in your own good sense to give clients hopefully the best estimate of what their case is worth, and emphasize again the variation that in any individual circumstance it could be all over the map. Are there any questions? They seem to think there's going to be this burning desire. Yes?
Tell us about mediation.
Sorry?
Tell us about mediation.
Oh, okay.
And then hand out your cards.
And then hand out my cards. No, that's why I put my address in my email. Mediation in wrongful dismissal cases works very well. Having experienced yesterday, it doesn't work as well in disability cases. No, it really works well in wrongful dismissal cases for a number of reasons. Unlike personal injury cases, our cases do not get better with the passage of time. They are not like wine, they're more like fish. They get stinkier and worse as time goes on. Experienced lawyers are now bringing me mediations before they even start lawsuits, in the first and second month. And the whole atmosphere is different. First of all, the plaintiffs still believe they might actually get a job one day, so some employers like that because they can shorten the notice periods. The process works well. Behind every single wrongful dismissal case, there are two sets of emotional and ego-driven people. We all know plaintiffs are, but what I found in mediation is that employers are equally. And don't for a minute think that the employer is only driven by the bottom line. There's a human being or a number of human beings at the other side, on the employer side, and you need to understand what drives them, what motivates them, and what they fear. And I spend a lot of time in mediation doing that. The actual legal component in the mediation. On a case like this, we spend about 8 minutes on reasonable notice. I'll walk in, I'll say, in caucus, Howard, what's reasonable notice? And he'll say, well, I think it's 6 to 8. And I'll ask Kuretzky, what's reasonable notice, depending on what side? I think it's 5 to 6. And I don't I don't let the other guy know what it is. And then there's a crossover, and that's usually not a big issue.
Do you get paid for this?
I get paid for that. Yeah, sometimes not even that. So the human element, that's my one comment in mediation, is extremely important. Yes?
You say that occupation is the least important factor. Is that the view held by Ontario courts currently? Or is this in other words, if I have a top executive who's 55 and has worked for 2 years, am I entitled to look at your little chart and say 4 months notice?
No, if I represented that person now as a plaintiff, I would ignore my charts. Because I would want to favor the in Ontario, occupation is more relevant than in other provinces. And especially an extreme example like that. But what I'm saying is the difference between, in the old days, when you still have Kronk floating out there where clerks shouldn't get more than 12 months and that sort of stuff. So I think it's more relevant, an argument for the lower ranking ones.
I think Howard's going to put that question on the judges panel at the end, so stay tuned for the end of the day.
Yes?
To what extent are judges prepared to look at your database?
Okay, it has been cited specifically in a number of cases. If you need a judicial reference, it's a case called Slater versus Reebok, the guys who make shoes. Mr. Justice Rosenberg commented favorably on it. He also commented on other ones, but I don't have the site, but it's an OR site somewhere. And there's a number of cases that have used it. I'm also told by a number of pretrial judges that it is routinely used in pretrials to the degree that a lot of judges say, okay, where's the database result on this case? Sort of nice. I also, when I was practicing more in the area, I used to send it off in demand letters. You know, typical demand letter, piece of garbage, nobody wants to read it anyways. You get a typical demand letter that says, I think reasonable notice is 12 months, and here's my research for it. You know, right away impresses the HR manager, and when he phones up the lawyer and he gives an off-the-cuff answer, they say, well, I'm looking at this piece of paper. I use it in mediation often. Very useful in mediation. It's objective. People can read it. Oh, really? I'm up. Sproat's up. Thank you very much.
New PowerPoint. It's my real pleasure to introduce John Sproat. I'm sure many of you know John is a senior member of the Employment Bar. John's book on his employment law manual and Charter of Freedoms and Equality Rights, 2 excellent texts. I always enjoy litigating with John. His real claim to fame, though, is he endured practicing with Mr. Gans for a number of years and can tell the odd joke, but about Artie. I have to get back at Artie for some of his comments yesterday. I warned him last night I would do that. John's going to speak about the Canada Labour Code for the federal employers. It's also important to note that the same legislation, virtually the same legislation, exists in Quebec. And so you're often called upon to give advice quickly on what's happening by your clients in Quebec and bear some of the principles in mind. And I think he's going to spend some time highlighting the reinstatement issues, as well as some of the other wonderful remedies that some of the federal employers, John, need to hear.
Thank you very much, Barry, and good morning. The single most important thing to take away from my presentation this morning is simply to turn your mind in any sort of termination situation, if you're advising employees, to whether or not the Canada Labour Code may be applicable. Most of my practice is representing employers. A number of them are federally regulated, and I can tell you that I've certainly been involved in discussions with clients where we may be saying, this termination could be a real problem. We may get a Canada Labour Code complaint, and lo and behold, the person goes, they get legal advice, and there's no reference at all made to the Canada Labour Code, and it really is evident. Nobody has thought of its applicability. The 2 most significant features of the Canada Labour Code in terms of a remedy for employees are the remedy of reinstatement and the fact that compensation is not limited to a period of reasonable notice, and to some extent those go hand in hand. If you've got a relatively a junior short service employee, if you looked at Barry's charts, that person might come up with 2 or 4 months. On the other hand, if that person is eligible to file a Canada Labour Code complaint, if that complaint is heard 18 months after termination and they're ordered reinstated with back pay, you've got somebody with a profile of an entitlement to 2 or 4 months who's getting compensated for 18 months. Now, like many broad statements, I'm sure this is a somewhat unfair statement, but very often the Canada Labour Code remedy is the refuge of the mediocre employee, the employee who is disruptive, the employee who is not likely to find new employment quickly. Because when you think about it, a typical person who's been dismissed, perhaps on a reorganization, perhaps a personality difference, perhaps one of those situations where people say it's not a good fit, what does that person typically say when you meet them? They say, I'm going to find a good job fairly soon anyway, and they say, I wouldn't go back to that company if they paid me. But the Canada Labour Code typical complainant is somebody who really is very concerned about their ability to find new employment, and for that reason is prepared to pursue the remedy. And the claim for reinstatement is really the stick that the Canada Labour Code complainant has, because if it comes right down to it, a lot of employers will pay a lot of money to avoid reinstating somebody they just don't want. In my paper, I make reference to The jurisdiction under the code, and as you might expect, if you cast your mind back to law school, it's the railway companies, the shipping companies, interprovincial transport companies, banks, broadcasting companies, and so on that are federally regulated. The Canada Labour Code remedy does not extend to employees who are categorized as managers. And as you might expect, there's a long line of cases dealing with who is and who is not a manager. Typically, a manager is somebody who's involved in hiring, firing, appraising people, budgeting, entering into contracts, people who exercise some sort of discretion and autonomy. So in taking a look at a Canada Labour Code case and whether or not a complainant should pursue it, you need to consider whether the person might be a manager. Because if they might be a manager, you can waste a whole lot of time and money in pursuing that complaint, and if it's determined that the person is a manager, then you've really wasted a lot of time and money. The Canada Labour Code unjust dismissal remedy is only available to employees who have completed 12 consecutive months of continuous employment. So again, if you're on the other side of the equation, federally regulated employers have to know that you've got to assess your employees and try to make the best decision you can within the 12 months before they get that Canada Labour Code remedy. Secondly, a complaint under the Canada Labour Code has to be made within 90 days from the date of dismissal. So that's a relatively short limitation period, and obviously the last thing you want to do is to miss that limitation period. Another exclusion from the remedy is if a person has been laid off because of lack of work or because of the discontinuance of a function. And lack of work is perhaps relatively straightforward. Discontinuance of a function, the courts have actually given a fairly broad definition to that. In other words, if you've got a person doing a certain job, if you decide to reorganize and that person's job functions are parceled out to 2 or 3 other people so that you're adding and subtracting duties, that will probably constitute a discontinuance of a function. In other words, the company is still getting out the accounting billings. The company is still putting its sales force into the field, but if you reorganize the people who are doing it, you can probably mount a fairly good argument that you have discontinued the function of the individual being terminated. And again, if you're on the other side of this type of situation, there are a whole lot of terminations that you want to characterize as a reorganization. And in the business world, there aren't many situations in which you can't add some duties to one person, subtract from another, and change the titles around a bit. So from the company perspective, you want to discontinue functions and try to either avoid or create some doubt about the Canada Labour Code remedy by doing that. Interestingly, and I addressed this in my paper, even the fact that an employee has executed a termination agreement, in other words, signed a release, may not bar an unjust dismissal complaint. Now, what happens is employees can't contract out of their code remedy. Even if they've concluded a settlement, they can file a complaint. Having said that, the minister has a discretion to not appoint an adjudicator, and a minister might well decide to not appoint an adjudicator if someone has been given a fair settlement and has had legal advice. But that may very well be helpful to you in situations in which perhaps somebody has entered into a settlement that really is improvident. Under the Canada Labour Code, employees have the right to request a written statement of the reasons for dismissal. And so if you're acting for an employee, I think you want to ask for those reasons just as quickly as you can, because if you catch the employer off guard, the employer may well state certain reasons quickly, and it's very difficult for the employer to later shift ground and rely upon different reasons for the termination. Under the Canada Labour Code, there is a process whereby an inspector will attempt to assist the parties to settle. The inspectors have a lot of constraints on their time. Don't expect the inspector to be acting as a mediator, but the inspector will go back and forth a bit to see whether or not there's a way to settle. With respect to what constitutes unjust dismissal, it's a somewhat broader and different standard than just cause at common law. It tends to be more the standard that arbitrators would apply. As you may know, in a typical wrongful dismissal case in the court system, incompetence can sometimes be almost an impossible ground to prove just cause. In other words, if the incompetence doesn't merge with some sort of deliberate misconduct, a lot of judges won't find it's just cause for dismissal. Canada Labour Code adjudicators apply more of an arbitral standard in that regard. Remedies, as I say, reinstatement, I think, is the stick that employees use to get a good settlement. There aren't that many employees that really do want to go back and continue on their employment. And the Canada Labour Code actually has a provision that says, in addition to ordering compensation and reinstatement, the employer can be ordered to do any other thing that is equitable to require or to remedy or counteract the consequence of the dismissal. This leaves open innovative remedies such as requiring letters of recommendation. It also allows some latitude to order the employer to pay damages which may extend into the future on the theory that, given that the employee has lost a particular type of job, they've taken a step backward in their career and they're not going to get back to that position, perhaps for 5 years. You can at least make an argument that that type of reduction in future earning ability is something that can be compensated. Now, whether you can persuade an adjudicator to do so is another question. That completes my submission, I think, right on time. Thank you very much.
See everyone back in 15 minutes.
You want to do a couple more questions?
Unless there are any questions.
Yes, Mr. Fisher.
Actually, when you mentioned the groups, the one group that you didn't mention, it's fascinating though, is Aboriginal bands are under it. I read all the cases in Howard's service and I don't know, 20 or 30% of the cases seem to be from Aboriginal bands. And it's fascinating because from a labor relations point of view, you've got a small community-based, family-based employer and race-based, obviously, or nation-based. And they are forced to deal with a situation that in a very tight environment where there's lots of community and rivalries going on, they're forced to deal with a situation that very few employers are, that is having to take people back. I just wonder if you have any special comments on the where your comments on where an arbitrator has exercised his discretion not to reinstate, given small communities.
We have to repeat the question. I won't repeat it all, but just for the purpose of the taping, but simply, have there been cases in which there's been an order of reinstatement in Aboriginal bands, and in which the cases have commented upon the specific nature of the bands, the family community, the small community?
Yeah. Barry, certainly there are cases that talk about whether or not the remedy of reinstatement is appropriate in that type of situation where people have to work very closely together, where there may be a lot of personal antagonism. But having said that, some adjudicators have said that it's sort of the characteristic of any breakdown in the employment relationship that there is going to be antagonism, there is going to be great difficulty in working together in the future, but nevertheless, the remedy of reinstatement is sort of the hallmark make-whole remedy. So I think in your Aboriginal band situation, perhaps in remote communities, perhaps a small group of people, there may be an argument that reinstatement is not appropriate. But I can tell you in a lot of larger company situations, you can have very nasty disputes, and adjudicators will still say reinstatement is the appropriate remedy if the employee wants it. As I say, a lot of employees at the end of the day are not really keen to walk back through the door and, join the sales force when they know that people don't want them there. Having said that, if they can use that to get some more money, good for them. Yes, David?
John, do you have any particular insight as to, I guess, how much or the extent to which 240 adjudicators have increased compensation in lieu of notice in cases where they have determined or the employee has asked that reinstatement not occur?
You're talking about the person gets to the hearing, they get compensation in effect up to the date of the hearing, but then they say, but I'm suffering damage that's extending into the future and I want something extra.
Right, and my sense is that, and your paper may deal with it, I'm not sure. My sense is that adjudicators will certainly ratchet up the amount of compensation in lieu beyond what traditional common law factors would call for.
Well, it's a bit like arbitral jurisprudence. There are cases that are all over the map on that, but there's absolutely no doubt in my mind that the Canada Labour Code provision that I read does authorize some sort of compensation that's extending into the future, and I think it's up to good advocates on behalf of their clients to put forward a persuasive case on that.
I find a lot of it has to do with who you get. Jeff England, for example, who I've had as an adjudicator, believes that the hallmark of the Canada Labour Code is a make-whole remedy, and you are not supposed to substitute damages in lieu of reasonable notice as in a wrongful dismissal case. You're always supposed to give them their job back if they win, or if they don't want their job back, pay them into the future if they're still unemployed.
He's the adjudicator, Howie, that early on in the when the cases started coming out, ensured that the individual got his turkey.
Did he?
So as part of the remedy was he missed Christmas turkey, and he got the order included the Christmas turkey.
A little bit is where they come from. If they come from an arbitration background, then that's what they tend to believe in the make-whole remedy, as in the arbitral jurisprudence. If they come from a different background, they may look at a common law standard, and there's no real, the Federal Court of Appeal has dealt with it, and that's, I just noted, is referred to in John's paper, but not in dispositive fashion.
Okay, Barry's telling me we'll take one more question. I think there's a gentleman out. Yes, sir. I mean, I can provide you with a sort of a general overview. You file the complaint, the inspector will, as I say, go back and forth between the parties to some extent. In my experience, typically a lot of the adjudicators will schedule a meeting with the parties in advance of the adjudication, and very often that's an opportunity to say, we want documents, we want to narrow the issues, and at least my experience with a few adjudicators has been that with the consent of the parties, they will actually almost attempt to mediate the dispute. Barry, what's your experience?
It's often you get cooperative counsel on the other side in terms of getting production and documents, and sometimes you don't, and what you do is the first day of the hearing is for the production of documents, and you may have to subpoena the other side to get the documents, and they'll come with the documents, and it actually proceeds very much like a confrontational union matter at arbitration.
I often set up conference calls in advance to get orders from the adjudicator. But another thing I find is useful with adjudicators, and most will do this now in the environment that Barry's creating, is mediations, and ask them, even privately, I think this case should be settled, depending upon whether that's strategically the right thing to do or not, and if you'll help, that would be of assistance. And then they'll, not necessarily without even disclosing the fact you've had that conversation, take the other side aside and try and work out a settlement.
Thanks very much, John. We're going to try to keep the schedule today, so if we could just have a quick coffee and come right back, I'd appreciate it.